Hello, I am Mohammad Mahmoud Al Hassan. I am an advocate of Bangladesh Supreme Court, and today I am going to make a short brief about the law of Writ in Bangladesh. The law of Writ is a very important constitutional right in Bangladesh, and also it is an exclusive jurisdictions of the High Court Division of the Supreme Court of Bangladesh. As we are very much concerned that the writ is a very important part of law, and this is internationally and worldwide accepted because each country of the world they exercise the writ in their own judicial system. In our country in the legal system of Bangladesh, the writ is a very important and integrated part, and also this is the part of constitutional law. Article 102 of the Constitution of the People's Republic of Bangladesh deals with the writ jurisdiction of the Honorable High Court Division, and the writ can be exercised for the different factors. Although the constitution makers they did not mention the name of the writ in our constitutions and in the Article 102, but they have written the main aspects, the main issues of the writ in the constitution. As we are very much concerned about the fundamental rights in the constitutions of every country, and also the constitution in the People's Republic of Bangladesh. As you know that the fundamental rights are legally enforceable. If any fundamental rights is violated at the time, the aggrieved person can go to the High Court divisions for the establishment of fundamental rights for him. So in these circumstances, if any fundamental rights under the Constitution of People's Republic of Bangladesh is violated by the government or the government agencies, in that case that aggrieved person can go before the Honorable High Court Division and to file a writ petition in order to gain his fundamental right. So this is a very much important thing, and for the reason that the writ is a very much important, exclusive, and the superior jurisdiction of the Honorable High Court Division of the Supreme Court of Bangladesh. So in this perspective that I like to talk about the different types of writ. Although the writ has been mentioned in Article 102 of the Constitutions, and the writ has several kinds, as like the writ of habeas corpus, the writ of certiorari, writ of mandamus, writ of quo warranto. There are several types of writ, so that I would like to make a brief about this kind of writ. First of all, what is writ of habeas corpus? The writ of habeas corpus is a very important type of writ. The habeas corpus, it means that to have the body before the court. If any person is detained by the government forces or by the forces without any kind of case or legal factors against him, sometimes any person can be detained by the government agencies and no complaint or no allegation is brought against him, and for that reason that person, the aggrieved person, can come before the Honorable High Court Division and to file a writ of habeas corpus. So this is a very important part of writ. This habeas corpus writ is not only available in Bangladesh and also the different countries. UK, this kind of writ is very much available, and this habeas corpus is a very important type of writ. The another type of writ is the writ of mandamus. The writ of mandamus, it means that something is legally bound by the government agencies to do, but they are not doing it. Suppose a government agency is bound to perform any particular duty or responsibility as per law, but they are not complying that kind of duty or responsibility. In this factor that aggrieved person can file the writ of mandamus before the Honorable High Court Division, and in that case the Honorable Court can give the directions to comply that rules, to comply that act, so that that agencies will be able to will be bound to comply the order of the Honorable High Court Division. On the other hand, another kind of writ is writ of certiorari. The writ of certiorari is also very much significant indeed. The writ of certiorari, it deals with the matter that when something has already happened. Now, suppose a government agencies, a government institutions has already done something, did something which is already done, but it has been illegal. Something has done which is illegal. He is not complying with the law of Bangladesh. So in that case, that any aggrieved person, they can file the writ of certiorari before the Honorable High Court Division, with the prayer that that act has been done by the government agency is illegal and not binding upon him, and this is unconstitutional. So in that particular sense, that the Honorable High Court Division, they consider that whether the act which has been done by the government agency is legally unlawful or not. So if the government agency if the Honorable High Court Division finds that the act which has been done by the government agency, that is not lawful. So in that case, that Honorable High Court Division can declare the act of that government agency as illegal. So this is a very important type of writ where the court can declare there's something act of the government agency as illegal and not binding upon the people. So it is also very much necessary things. And another type of writ, it is a writ of quaranto, that if any person holds any public any government office which is not actually legally he is entitled to do. Suppose a person has been appointed for any particular post, but as per law he is not legally entitled to hold the post. So in that case, the aggrieved person can file the writ of quaranto. So at the time, the court shall reconsider the overall issue whether the person is legally entitled to hold the post or not. So the court can determine about this kind of issue. So this is really very much significant things. So the writ is a very important part of for establishment of fundamental rights of the people of the People's Republic of Bangladesh. And also in this case, the Constitution of People's Republic of Bangladesh has given the exclusive power to the Honorable High Court Division to deal with the matter of writ. So that the writ always gets some importance in the Honorable High Court Division, and also the aggrieved person, they also get come to the High Court Division, Honorable High Court Division, for the establishment of their fundamental rights. So in this case and circumstances, we like to say that the writ it is not only the law in Bangladesh. Also the writ is available in almost all of the countries in the world, because although by the separate system or several law, but this is one kind of international or universal system by which the Honorable Superior Court, or in the different countries, and in Bangladesh Honorable High Court Division of Bangladesh Supreme Court, they can exercise the power of writ under Article 2 of the Constitution of the People's Republic of Bangladesh. And it is to be understood that the writ can only be exercised against any government agencies or government institutions. Then normally the private institutions is not under the jurisdiction of writ, because a person cannot file a writ against any private individual. The writ has to be filed against the government agencies, government institutions, or something related with the authorizations of the government. So it is the basic and fundamental things of writ in Bangladesh. Although there are so many issues, and we'll discuss in near future about this matter, but this is for the primary concept, the law of writ in Bangladesh, which I describe for my honorable Facebook friends and other social networking friends. So thank you everybody, thank you very much for watching my video with patience.